A CCA is advice from the government, a Chief Counsel Advisory memorandum. It lays out the government's position on a particular issue. Why it's so important is it conveys the service's litigation position. So it shows you what the service thinks about an issue and their likely position in litigation. The moral of the story is if you have an existing trust, it's a grantor trust, and you add a reimbursement clause, the government's position is that that's a taxable gift from the remainder beneficiaries back to the grantor. So that's a big thing. Now, that's only if you go back and you add that through a decanting or through a reformation. If you draft that into the document ab initio from the beginning, you're fine. That's black letter law. Revenue Ruling 2004-64 lays out that position. That's 20 years old. However, if you go back and add it into the document, that's when you're going to have a problem. And if you look at other litigation that's been out there recently, Annenberg, McDougall, the CCA, they all speak to the same thing, that if a remainder beneficiary gives up rights in favor of the grantor or in favor of someone that has a life estate, there's the potential for a gift. So we have to be very careful with this. So what Loper-Bright did, it basically said that the deference that's been accorded to the IRS under the Chevron doctrine is no longer there. The courts are going to interpret basically legal documents. The courts are going to interpret statutes and regulations. So where we are now is you have to look at how will this affect the service's litigation position. I don't think this changes anything on the CCA. Okay, it doesn't change anything. The CCA is the government's position on whether that if you add a reimbursement clause, there's going to be a gift. And clearly, that's where the service is right now. So we have to respect that. The CCA only came out in November of 2023. The IRS is going to do very little to acknowledge Loper. They're going to stand back and take the position that what they're doing makes sense and that they're taking the right position on how to interpret ambiguous statutes. So I don't think this changes anything.